Sister studio.
On the studio.
Pietermaritzburg Yes.
If you can hit us with a note, it's okay.
Recomposition.
Please hit us with one note of your music. Please hit us with a note of your music composition.
Oh, what
What Galu blame Jesus?
Sure. So this is
Taylor, how are you? You get it back?
I'm tired of this man.
Andrew, please put on your robe.
Just what happened to have a punch.
Not a punch.
The attorneys, the first thing I was taught when I was an attorney clerk is that when you walk around, you must always have a stapler and a punch.
Yeah.
But the attorneys of today don't do it.
They have a tablet.
Yes, exactly.
Order in court.
I order call the matter, the state versus Jacob Zuma and another.
May it please the court. My learned friends, Ms. Mayosi and Ms. Raja, appear together with me for the state.
Thank you.
May it please the court, my lord, I appear for the appellant in this matter, or the first accused in the criminal matter, together with my learned friends, Mr. Masuki, Ms. Kofa, Mr. Butelezi, and Mr. Kulu, instructed by two senior attorneys.
Yes, thank you.
As it pleases the court, my lord, I appear on behalf of the second accused.
Thank you, Ms. Jackson. Yes, Mr. Mpofu.
Thank you, my lord. My lord, if I may just start with a few housekeeping issues or signposting issues. I'm going to address there's a multiplicity of legal issues that have been raised by both parties. Points in limine and a counter application. I'm going to address those issues, the legal issues, upfront. Mr. Masuku will deal with the merits of the application, namely the issue of prospects of success and other compelling grounds. Now, it's important for me to try and organize the points that I'm going to deal with, because firstly, there are, as I said, a multiplicity. There are about 6 of them, but I'm going to group them into 3 just for the sake of economics. But also, my lord, to try and save time, as your lordship knows, inevitably, some of the legal issues will stray into the merits. So insofar as I may deal with the merits in the context of the legal issues, Mr. Masuku will not then deal with those aspects that I've already dealt with. We have made an arrangement of which issues. So the issues that I'm likely to stray over would be the legal grounds of appeal, but the factual grounds of appeal I'll still leave to Mr. Masuku. Thank you, my lord.
Yes.
The second issue, my lord, then coming to my section of the argument, is to try and outline for your lordship how the legal issues are going to be approached. And as I said, there are 6 of them, and I've grouped them into 3 groups. Group 1 will be the 2 issues raised by the applicant, namely the procedure point, which I will explain later, is also a section 9 point, or it has also now morphed into a section 173 point, because the defense raised by the other side relates to section 173. Then the second issue raised by the applicant is the issue of the deponent issue, Advocate Downer as a deponent. Again, I won't explain it now. I'll explain it when I get to it. Then what I call the group 2 issues will be the issues that are raised by the state, which we have to respond to. For the sake of shorthand, I call those the section 316 issues. That's because they raise primarily section 3161A, which we may call the appealability issue. And the second one is under 3165. Actually, technically, this one is raised by us, but it has been opposed on the basis that, and that is the application to adduce evidence, to adduce new evidence. I'm just grouping it here because they both come from section 316. Then, my lord, I will deal with the group 3 issues, which are part of the so-called conditional counter application. And that is the section 317 application for a special entry, and the section 319 reservation of a point of law, which is related to the section 173 point. So those are the issues that we will address upfront, my lord. There is, or there may be, a preliminary issue of condonation, which we understand has not been opposed. We would, if your lordship is so minded, we would deal with that now so that we
Yeah, well, let's cut to the chase on that. I've received the application. I've taken note of it. The late filing of the heads caused because of my work schedule and having planned around that. Serious inconvenience, but I'm not wanting any further delay in the matter.
Thank you.
So you may proceed and you may refer to your heads of argument.
Thank you, my lord. You're indebted to your lordship.
But it will have certain implications, such as I'm obviously going to have to reserve
It might have
because
to do to the. No,
I haven't had the time to look at all the cases.
no, of course not. No,
I've done the best that I could in the time available.
Yes, my lord. No,
Yes.
Unfortunately, Mr. Masuku's illness was unpredictable.
Yeah.
Thank you, my lord. Well, then, my lord, let's then get right into it. Lord, I want, for reasons that will become clear just now, to start with what I have called the procedure point, which I will fashion as also as a section 9 point, in which the other side have fashioned as a section 172 points. Simplified, it goes like this, my lord, and it's important because it will determine which of the documents, let's call them for now, the pleadings are in, which are not in, and why. We have raised the issue, my lord, that the procedure adopted in this matter is irregular and out of the ordinary, to say the least. And the procedure we're talking about is the directive that came from your lordship that after the filing of the application of the notice of application for leave to appeal, the state would be required, entitled, or whichever way you look at it, to file an answering affidavit, and the defense or the applicant, if they so wished, to file a replying affidavit. Now, in my experience, I've never seen anything like that. I don't know, there are maybe 12 or more lawyers here. Total, probably the experience will be more than 300 years. Maybe some of them have seen it, but speaking for myself, I've never seen it.
Can I cut to the chase on that as well, Mr. Mpofu?
Yes, my lord.
The intention was never that affidavits be filed in the application for leave to appeal. The alleged irregularity that's referred to is taken from one letter. It's not construed in the context of all the letters that were exchanged since the time when the application for leave to appeal was initially launched. And properly construed in their context, it is abundantly clear that an answering affidavit could only be filed in response to a finding affidavit. The only finding affidavit was the one in support of the application in terms of section 3165 for the further evidence, which was subjoined to the application for leave to appeal. It has been misconstrued, and in my view, in the proper context, shouldn't have given rise to this problem at all.
Well, my lord, then I will approach the matter on the basis of how we construed that directive and how, incidentally, the state also construed it. Because when they responded, they did not confine themselves to the application for to lead further evidence.
Mr. Mpofu, how is that relevant to whether the judgment dismissing the special plea is correct or incorrect?
It is very relevant, my lord, because procedural rights, contrary to popular belief, are as important as substantive rights. If you get the procedure wrong, or in such a way that is oppressive to a litigant, Then, however correct the substance might be or incorrect, then that irregularity taints the entire proceedings. That is the whole philosophy behind Section 317 and 318 and 319 of the Criminal Procedure Act. Because the so-called special entries that are referred to in those sections or points of law usually relate to irregularities outside of the merit. So it is of no use to ask why. Well, let's say the merits are good or bad, therefore let's forget about the alleged irregularity. No. Particularly in a case of this nature, my lord, and I'll explain this. That's why I was speaking about Section 9 of the Constitution. The applicant, former President Zuma, is of the strong view that at some stage this issue has to be addressed of his cases being treated differently from other cases. And as I said, and for now, my lord, let's assume that the way we have construed the directive to us and our learned friends is the correct one. I hear what your lordship has said. Then the issue really arises because what he says is very simple, and your lordship is going to have to allay his fears that why would a procedure that is unheard of, to put it crudely, be adopted in his case? And it's not for the first time. We all know the court can take judicial notice of the fact that he has raised this complaint repeatedly, but repeatedly. He's the only person I know, at least again, I might be wrong, there might be others, who has had to spend time in a prison cell without ever having to cross-examine anybody, without a particular process. And from his point of view, that was a unique situation that was designed just for him. He may be right or wrong in that belief, but it is a belief that causes consternation, to put it mildly. If I may digress, my lord, but it's a relevant consideration. Again, I'm speaking about my own experience. I have never seen any person, accused or not accused, in respect of whom the law seems to be so over-eager and speedy to, summarily deal with him. In the past 6 months or so alone, we have had the unique experience of bringing an application. The first one was in the Constitutional Court, which we brought in the normal course. But within 24 hours, on a Saturday, there was a directive, no, you must do this, do that. It was not an urgent application. Fine. Secondly, we've had another application relating to the parole of Mr. Zuma. Again, Part B was not urgent, but it had to be heard within the next 2 weeks. The application for leave to appeal was even heard on the 21st of December. I had to cut down my holiday and rush and try and get robes in the Eastern Cape. I don't know why. But now, here again, we had the experience of the other side saying, no, this matter must be heard in November, this one. November, let's rush. And we got a directive that, yes, it can be heard from the 15th of November. Unfortunately, we were not available. Again, this was just a normal application for leave to appeal. So that's the context within which President Zuma raises this point, my lord.
But you were accommodated in that respect.
No, we were. In fairness.
Yes.
No, we were, my lord.
Now, I considered it very carefully. I was
Yes.
concerned about a 2.5-month delay,
Yeah.
but because of the factors that were advanced in the letter of Mr. Tusini, which is not annexed, which is one of those that I referred to, I considered that it should nevertheless only be heard today.
And give us
And it
the
was in that context that the matter was being regulated.
Fair enough, my lord. That I accept. I'm simply saying before Mr. Tusini's letter, there was some kind of consensus that this must be done within 5 or 6 days or whatever. So it is in that context that, and even when Mr. Tusini's letter came, your lordship told us that no, this matter cannot be delayed any further and so on. But your lordship is quite correct. In the end, we were accommodated. Now, I'm just saying that that's what I'm back in. I'm just saying that's the context within which a litigant like Mr. Zuma is viewing these things. So when it happens now that there is a situation where he perceives that a procedure that is, as I've said, unheard of, is directed at him, then he has all the right to raise that issue successfully or unsuccessfully. So that's the context. What is the connection between this and Section 9 of the Constitution? You know, when we talk about Section 9 of the Constitution, we all talk about the fashionable Section 9.3, talks about racial discrimination and gender discrimination and so on. And we forget Section 9.1 of the Constitution, which says that everyone is equal before the law and is entitled to the protection of the law, to the equal protection. This is a very serious matter, my lord. At face value, it might look trivial to someone who's not in the position of Mr. Zuma. And that is because, my lord, we have to, for once, just step into his shoes and say, what would you, if your lawyers tell you that all of them, you ask this a whole array of lawyers, and all of them say, I've never seen this process, this procedure, and you are a lay person, what must you feel? And more so, my lord, because we are told that, you know, I cannot even count the newspaper articles or so-called expert commentators who say that every time Mr. Zuma is treated differently to other people, it is to show that we're all equal before the law. Well, that's a joke, because it can be that we show that we're equal before the law by treating a particular individual differently from all the other people. That's just wrong. So if we are equal before the law, let's be equal before the law. Let's not have a Zuma law. Let's not have some laws that are uniquely reserved for him, because that flies in the face of Section 9.1 of the Constitution, which says we're all equal before the law. We can't be equal before the law only when bad things happen, but we are not equally entitled to all the good things. Now, my lord, the issue here is a very fundamental one, which is that the procedure was therefore at face value in breach of Section 9.1 of the Constitution. And apart from it being I mean, there's such an established applications for leave to appeal are heard day in, day out in our court. So there are established rules. It might well be in the civil courts, we know that it's done in terms of the rules and section 17. But even in the criminal courts, it's a common occurrence. So, my lord, the other side then says, the other side didn't come with the explanation that your lordship has just given us now. As I say, because they understood it in the same way as us. So they say no, and this is what we said in our heads. We don't know how they got into your lordship's head to know that your lordship was applying section 173 of the Constitution, which turns out that is false now, because your lordship has just told us that the reason had nothing to do with section 173. It was simply to deal with the section 3165 application. So they were wrong, and maybe they can be forgiven for also misconstruing your letter. But for what it's worth, and I won't belabor this point as much as I wanted to deal with it, because now it's of academic importance, because that defense clearly doesn't accord with what your lordship has now told us. But if it ever comes again, let me put it to rest. Section 173 has got nothing to do with this approach. Section 173 of the Constitution, yes, empowers a court to regulate its own procedures. But a court cannot just regulate its own procedures in the air. There must be reasons why Section 173 has to be resorted to. And our courts have placed those reasons in many cases that your lordship is familiar with, S versus Atchison, the cases that the prosecution relies on in this regard include Phillips case, SABC case, and S versus Western areas, to mention a few. And we all know they claim that it is nevertheless in the interests of justice, or to make matters worse, they claim that it was in the interest of justice and presumably in Mr. Zuma's own interest that such a unique procedure be adopted. Well, to paraphrase, and as I say, I'm not going to go deep into those issues. Nothing could be further from the truth. It has been said repeatedly that the courts must resort to Section 173 in order to assert their impartiality. And it has also been said that resort must be done sparingly and only in the clearest of cases. And when, according to the Phillips case, at paragraph 48, to meet an extraordinary procedural situation pending enactment of relevant legislation and promulgation of rules of procedure, it may be that the High Court could legitimately claim inherent power of holding the scales of justice where no specific law directly provides for a given situation. all that does not apply here. I just want to jump some of this. And yes, okay. So to save time, I won't go through the grounds given in Pennington. As far as Pennington, I'll just give you a lordship the citation. It's 1997 4 SA 1076 CC. And interestingly, one of those grounds deals with applications for leave to appeal, but I just want to move on. In the Western Areas case, my lord, it was stated there, and I want to, I'm addressing this to kill two birds with one stone, also to deal with this issue of speed, what I call undue speed, of trying to deal with these matters. There it was said, my lord, that it is surely not in the interest of justice to submit an accused person to the strain, expense, and restrictions of a criminal trial if it can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence, and so obviating the trial or substantially shorten it. And I'll come to that question when.
Which paragraph are you referring to there?
It's 28.
28, thank you.
I'll deal with that. I won't quote it again, but I'll refer to that paragraph also in the context of the objection by the state that this application should be brought only at the end of the trial, or something like that. Which, by the way, there's another overlap with your lordship's findings. If your lordship allows me just to also flag that issue, I'll come back to it. Mr. Masuko might also deal with it, but let me just say this now so that it's out of the way. The governing philosophy of this judgment that we are here about is that this matter, this plea, this complaint about Advocate Downer should be raised at the end of the trial. Or should not be raised at this stage, or words to that effect. I'll go to the judgment itself. Well, on that ground alone, on that basis alone, the application for leave to appeal, at least on the merits, should be granted. Because the cases, such as the one I've just cited, are replete with references of the fact that it is not in the interest of justice to submit an accused person to the strain, expense, and restrictions of a criminal trial if that can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence so as to obviate the trial or to substantially shorten it. Now, all that is cast aside when it comes to former President Zuma. No, he must be put to that strain and the expense and the personal restrictions. An old person must sit here for 6 months going through a trial which might be of academic use, because he must only complain about Advocate Downer 6 months or 12 months or 18 months down the line, however long the trial is going to take. How can that be justice? How can that be even approximately called in the interest of justice? Justice to who? Now, coming back to the issue of the deviations. Our learned friends say that we must show that there was prejudice. Well, there's no such requirement in law with respect. If a constitutional violation has been made against you, you don't have to show prejudice. That is the prejudice, the fact that your constitutional rights have been violated. You can't insult a person for argument's sake. And then when they take it to court, you say, well, or call them a kafir or whatever appellations are used to insult people. And then say, no, what is the prejudice? That's the prejudice. The mere fact that you have violated their Section 9 rights is prejudice. The prejudice which they refer to is in another context, which I will deal later, but not in this context. So there is no law anywhere. In fact, let me put it this way. Section 173 must be used to assert the impartiality of the courts, not to practice it, not to assert the exact opposite and the unequal treatment of people, because that would just be doing violence to the intentions of the drafters of the Constitution. So, my Lord, we, on the common understanding of the parties as to what your directives were saying, then it is a matter of serious grievance on the part of the applicant, because there is no reason. As we know, rights can be attenuated, even his Section 9(1) rights, but there must be a justification, and that justification cannot be the fact that his name is President Jacob Zuma. It must be a rational justification, and none has been offered. I may come back to this, but for the sake of time, I want to move on to oh no, let me also say this, because it might help us when we get to the special entries or the counter application. We have entered a special entry and raised this matter also as a question of law. And I don't have to repeat how we frame it and view it as a question of law. It's obviously a question of law whether somebody's rights under the Equality Clause have been observed or not, or whether he has been singled out for special treatment. But that question is a question we seek to place before a higher court, specifically the SCA. And we do that in terms of Section 317, alternatively 319 of the Criminal Procedure Act. But let me explain something, my Lord, just for, it's a procedural point. The reason why we call that section conditional counter application is because, of course, it is dependent on the finding on the merits. We acknowledge upfront in the authority for that, that should leave to appeal be granted, and your Lordship knows that your Lordship has acted in the SCA. The SCA would be at large, for lack of a better word, to deal with all the issues that may be raised at that stage, including so-called special entries and what have you. All legal points. It's no longer like in the olden days where you are restricted to your notice of appeal. You may raise now any issue that is valid. So it's conditional on in that sense. If your Lordship, after Mr. Masuku's address, finds that either the reasonable prospects of success on the merits, or there are compelling reasons why the application for leave to appeal should be heard, then all these points will fall into that category. But if your lordship finds that those standards have not been met, then your lordship, with respect, has no option but to still grant the application for leave to appeal on the basis of the special entry and the reservation of the question of law. This is not a matter that is within the discretion of your lordship. Once we've entered a special entry, then your lordship has to refer that to the what was used to be called the AD and now called the SCA.
We take it, Mr. Mpofu, that although the notice referred to full court or SCA, you're talking about the SCA here.
Yeah, my lord. Yes, I'm sorry. I should have made that clear, my lord. The standard notice that the
No, that's fine.
Yes,
You don't have to explain it.
No.
You confirm
and I'm
it's
sure
SCA.
Mr. Breitenbach will also approach
Yeah.
the matter on that basis. Yeah, well, we're really talking about the SCA for various reasons, my lord, including the fact that there's SCA authority, which is contested here. So, with the greatest respect, a full court appeal would just be a waste of time or cause further delays. In our respectful submission, the matter should go straight to the SCA. So,
So, Mpofu, why were there two replying affidavits filed and this issue not dealt with simply in the affidavit of Mr. Tusini?
I'm sorry, my lord, I didn't get that.
Why were there two replying affidavits filed and this issue of the alleged irregularity not simply dealt with in the affidavit of Mr. Tusini?
Okay. No, the reason for that was to underscore the point that we were making, that you remember that in the replying affidavit that was signed by Mr. Zuma, he says that we concede the fact that as far as the application for to adduce new evidence is concerned, the affidavits are allowed, but we contest the other. So it was really merely to underscore that point, and that is why we did not want to be somebody to come later and say, well, you've now replied, therefore you have acquiesced in this irregularity, because we have not. So we accept that the replying affidavit of Mr. Tusini in the other application is quite competent. We don't take that point. And by the way, our learned friends are completely wrong, because they say by adopting that procedure, we were thereby conceding that you can adopt a procedure which deals with affidavits, even if it's not prescribed by the law. Well, that can only mean that they have never read section 3165B of the Criminal Procedure Act. So on my version, it's at 31-6.
Yeah.
Because that section makes it clear that affidavits are not only allowed but prescribed. It says an application for further evidence must be supported by an affidavit stating that, and so on and so on. So that point is just a non-point. And there's no equivalent section, at least in criminal proceedings. We know that, and they also make the issue about the petitions to the SCA. That's also a non-point, because in the SCA, when you do a petition, by definition, you do an affidavit, a founding affidavit. You don't just start with an answering affidavit. But anyway, be that as it may. at least Mr. Zuma, even though he's not a lawyer, he has done petitions to the SCA. He knows that those are done on affidavit, and that situation is not comparable to what we're busy with here today. Now, I'm raising this point of the 317 and 319 in relation to what we're discussing now. A, to save time so that when I get to the so-called group three issues, I don't deal with it, but also to underscore the fact that it underpins the reservation of question of law, which we have raised, as well as the special entry. And as I say, even if your lordship, unless if your lordship use the same, is of the view that the point is not raised bona fide, or is frivolous, then your lordship has no option but to enter the special entry. And I've already explained why it is not by any stretch of the imagination frivolous or trivial. It is one of the most fundamental issues. Section 9, the equality clause, is very, very important, particularly to a person such as Mr. Zuma, who has been a victim of its violation at the expense of his own personal liberty. And it must stop somewhere. And this is the somewhere. Or well, maybe not this is the somewhere. The somewhere will be the SCA when that issue is raised there. Now, your lordship just bears with me. Just want to go to the SABC case. Yeah, at paragraph 49 of the SABC case that is relied on by our learned friends, the connection between section 173 and the fair trial rights is made in the middle of that paragraph 49. It says, moreover, the test adopted by the Supreme Court of Appeal inevitably and permanently privileges the right to a fair trial over the right to a public trial, the right to freedom of expression, and so on. In doing so, counsel argued it creates a hierarchy of rights inappropriate for a constitution such as ours.
So what paragraph is that, Mr. Boffa?
49.
49, thank you.
Yes, 49. There is another more appropriate quotation. I'm sorry, my lord. I'm struggling because I'm using my learned junior spec. Let me use mine because it's underlined at the right places. Yes, paragraph 17, my lord, of the SABC case says that the reach, or rather it says, while the clarification and protection of the powers contained in section 173 are matters of substantial importance, the Supreme Court of Appeal does not affect the substance of section 173 in a way which renders it desirable for consideration by this court. That's what was argued. that this was not a matter of substantial importance, the ambit of Section 173. And the court, this was the Constitutional Court, and it was SABC versus National Director of Public Prosecution and others, 2007 1 SA 523 CC. The court said, we disagree. The reach of a court's power to regulate its own process is an issue of great constitutional moment. And the current dispute raises the issue directly. In addition, the contention ignores the other constitutional issues of importance in the case, and in particular, the ambit of the constitutional protection of the freedom of the press. In this case, you might replace that with the freedom of equality before the law. And then, this is Langer, Chief Justice Langer, then went on to say at paragraph 35, Section 173 provides that, then he cites the section. This is an important provision which recognizes both the power to protect and regulate their own process, of the courts to protect and regulate their own process, as well as the power to develop the common law. It is the former that is of relevance in this case. It must be understood in the context of Section 165, which provides that the judicial authority is vested in the courts and that they are independent and must apply the law impartially and without fear, favor, and more importantly, or prejudice. And the next paragraph says, a primary purpose for the exercise of that power must be to ensure that proceedings before the courts are fair. Goes without saying that anything that is in breach of Section 9 cannot be fair. That would just be an oxymoron. Not something that is a source of inequality cannot at the same time be fair. It is therefore fitting that the only qualification in the exercise of that power is that courts in exercising this power must take into account the interests of justice. I've already addressed that. And it says, when the courts exercise the power to regulate their own process, it is inevitable that that power will affect rights entrenched in Chapter 2 of the Constitution. A court must regulate the way proceedings are conducted, and this will inevitably affect both the right to a fair trial and the right to have disputes resolved by the courts. Courts are bound by the provisions of the Bill of Rights and therefore bear a duty to respect those rights. In exercising the power, therefore, they must take care to ensure that those rights are not unjustifiably attenuated. That's the nub of the issue. The other side thinks that we are questioning the power of the courts to exercise Section 173. No, we're not doing anything of that sort. We're exercising whether it has been, in this case, exercised justifiably or unjustifiably, which is what the Constitutional Court said is the standard. Sorry, I'm going to promise a lot that I want to. Then, of course, the Constitutional Court said in the case of Phillips and others versus National Director of Public Prosecutions, in both, paragraph 48, my lord, in both cases, the points are made that ordinarily the power of in Section 713 to protect and regulate relates to the process of the court and arises when there is a legislative lacuna in the process. The power must be exercised sparingly, having taken into account the interests of justice in a manner consistent with the Constitution. So I doubt that the inherent jurisdiction of the court under Section 173 is such that, I'm at 52 now, is such that it empowers a judge of the High Court to make orders which negate the unambiguous expression of the legislative will. Moreover, the power that the court has to use in its inherent power is a special and extraordinary power which should be exercised sparingly and only in clear cases. This is not such a case. that's just a cross section of the authorities or of the constitutional. So it's a serious matter. It's as far as special interests are concerned, or even as we raise it here, which has to be adjudicated, starting, of course, now, given what has been said in court, with it will have to start with the proper interpretation of the letter, because clearly and we accept that your lordship's word on what was meant to be conveyed, but we in our respectful submission, the common understanding of the parties was different to that which we only hear for the first time now.
And also, I think I understand the point.
Yes, that is
Under this heading. I don't want to rush you along,
no, my lord.
but we sat down for today.
Yes,
I didn't ask you at the outset what sort of time intervals you were looking
yes,
at,
my lord.
but I think you've concluded now what you referred to as your first point,
Yes.
the
No,
procedural
I've
issue.
actually concluded 3, my lord.
Yes.
Maybe your lordship did not. Let me explain.
Now, you've touched on part of 3 as well.
Yes, of 3 issues. Yeah,
Yes.
I'm not. That's the whole point I was making. I'm not going to then go back to section 217 and 219, because the point I'm simply making is that your lordship, if your lordship is conditional in the sense that if your lordship finds against us on the merits, then those will kick in. But if your lordship finds for us, then your lordship doesn't even have to address those. So we've done 3 points actually.
Very well.
We're doing very well. So then let me then quickly dispose of the 4th point, which is the issue of Mr. Downer's
The deponent issue.
the deponent issue, my lord. Yes.
Okay.
Well, that issue must be married together with one of the issues that Mr. Masuku might raise on the merits, and it is this, my lord. Let me paraphrase it. The applicant's objection is that of all the people in this world, the NPA has chosen that the person to depose to its affidavit in this matter, which involves the title of Mr. Downer's title to prosecute, is Mr. Downer. That is just patently wrong. Your lordship knows, just by way of example, that one of the issues in Porritt, in the famous Porritt case, was and you'll find that even in the heading, it says the court upheld the plea holding that there was no reasonable explanation before the court why, as a prosecutor employed within the NPA, Ferreira, whoever he is, On the 21st of October last year, former President Zuma laid criminal charges against Mr. Down. And that is a matter that is before you, my lord, in the application to adduce new evidence. I don't want to deal with it now. So, in which world is it acceptable that a person who's being investigated is clearly not an accused, but at best for him is a suspect? That person, as I say, of all the human beings in South Africa, is the only person that the state thinks is competent to because the criteria that are needed, that application, as I've already pointed out, is about the introduction of the new evidence of the criminal charges that have been laid, as well as the supporting statement of Mr. Zuma in that application, or rather at the police station. Which your lordship will find that Mr. I'm sorry, my lord. It's Mr. Tusini's affidavit. It's 27, page 27
Yes.
onwards. And attached to that, your lordship will see something called at page 32, sworn statement in support of criminal complaint, which is an affidavit signed by the applicant, and he explains the charges in terms of section 41.6 and 41.7. That you'll find at page 34, my lord, of our bundle. And then it sets out count 1, count 2, and so on. And it's signed at page 39. And attached is a special power of attorney and so on. But let me paraphrase what's going on. What Mr. Zuma is simply saying is that this evidence, which elevates the earlier complaint, remember the earlier complaint was related to Mr. Soul and those kinds of earlier complaints. And it is now amplified by the latest, let's call it News 24 complaint. But now it is further amplified by the criminal charges laid in respect of that News 24 complaint. And all Mr. Zuma is really saying, it should be, honestly, I don't understand why anyone would resist this. All he's saying is that that charge was laid well after we argued this matter on the 22nd of September, the second day. And that charge was laid a month later, 21st of October. And therefore that fact, which might have a bearing on the title to prosecute, must just be taken into account and accepted or rejected or whatever. But it must be taken into account. And so it's relevant, clearly it's relevant, because it's relevant to the two previous issues. There's an explanation as to why it was not before the court by the time we finished our argument, because those charges, in fact, those charges had not been laid. In fact, Your Lordship will remember, unfortunately, we don't have a typed record here, but I'm sure, I don't know if Mr. Breitenbach was here, but at least Mr. Chenkov and the rest of the team will remember that I stood here on the 22nd in the morning and I said, this is the situation. These are the sections of the act that have been, of the NPA Act that have been breached, and Mr. Zuma is minded to lay criminal charges. Your Lordship said to me, Mr. Mpofu, we cannot discuss that because those charges have not yet been laid. And Your Lordship was correct. And I moved on to something else. So I can't be told now again, now the charges have been laid, that matter must be considered when the matter goes further. So quite frankly, there's no reason why Your Lordship should not accept that new evidence. And Your Lordship knows that unlike in civil cases, in criminal proceedings, or rather in criminal appeals, it's quite a strange process, by the way. The application to adduce new evidence is done here in the trial court. And the SCA, actually, you're not allowed to bring it for the first time in the SCA, unlike in civil proceedings. So all we would like is to say that application ought to be granted. My Lord, if I may then come to the last issue of the 6 issues, and that is the seemingly attractive notion raised by our learned friends to the effect that we should not be appealing at this stage because Section 316 5, or rather 1 of the Criminal Procedure Act says that you can only appeal once there's a conviction or an acquittal. I will demonstrate that that defense is just baseless, and it is not in accordance with our law. It is not in accordance with the rules of interpretation, and it is not in accordance with binding constitutional court authority. It is indeed so that Section 3161A talks about offense like that court for leave to appeal against such conviction or against any resultant sentence or order, and in many other places. Nobody is going to quibble with that. But my Lord, this matter must be looked once again. We live in a constitutional state now. So the interpretation of that section firstly has to take into account the broader standard of interests of justice, issues of appealability we shall deal with now, and whether such a narrow and parsimonious interpretation can be entertained in a constitutional framework. Because what this would mean really is that, once again, you must wait. You can have the biggest grievance in the world, life-threatening, but you must go through the tedious and expensive route of a trial, and then one day say, oh, well, I don't even know how you do that. Even if you are acquitted, let's say you get acquitted, then it means your complaint just fizzles away. But let's say you are convicted. Then at that point only, you must ask for leave to appeal against that finding that happened 2 or 3 years ago. And that's just patently ludicrous. Now, the way the courts have approached this, my Lord, is that there are 2 ways. One is from the point of view of appealability, which we know, which also applies in the civil law, the Zweni test and all that. But it has also approached it pragmatically in relation to criminal matters, in what I will refer to as the Basson test. Now, my learned friends, unfortunately, have attached the wrong Basson cases, and I don't blame them. There's so many of them. But the Basson matter that we're referring to is the 2007 matter. Yes. The citation is 2007-1 SACR 566 CC. It's a decision of the Constitutional Court. And that decision, my Lord, put paid to the theory advanced by the state. And
Which paragraph are you relying on, Mr.
of 152, my Lord.
152.
Paragraph 152, yes.
Thank you.
That shall come to me. Now, at paragraph 152 of Basson, it is stated that And I'll link this to the 216. But in our view, Section 219 should not be construed as to prevent an appeal against an order dismissing or upholding an exception. The section should be construed so as to allow the state or the accused to appeal against an order upholding or dismissing an exception. Such a construction of Section 219 brings with it constitutional bounds by recognizing the rights of the state to institute criminal proceeding and, if need be, to appeal an adverse finding on a question of law. It is this construction which must be adopted. It follows, therefore, that Section 219 did not prevent the SCA from considering an appeal against the order of the High Court quashing the charges relating to conspiracy. The SCA therefore erred and concluded that the Adams rule, that's the old rule that they rely on, constituted a bar to the reservation of questions of law relating to the quashing of the charges. Now, the relationship between 216 and 219 in this context is quite simple. But for shorthand, I'll just refer your lordship to, okay, this one I'm sure it's quite correct, it's the latest, 31-12 or in due toy. In the middle of that page, it says, after stating, my lord, that it was previously believed as in Adams and so on, it says, an order dismissing or upholding an exception is appealable before the conclusion of a trial, as versus Basson, at paragraph 152. A plea objecting to a court's jurisdiction in terms of 106(1)(f) is indeed such an exception. An appeal against an order dismissing a plea of no jurisdiction will be entertained before the conclusion of the trial, where it is clear that the court dismissing the plea had no jurisdiction, and in addition, where it is clearly in the interest of justice to permit an appeal against the ruling without an appellant first having to be exposed to the prejudice of an irregular trial. So you can then transport what I said earlier about the expense and restrictions of a criminal trial from as versus Western areas. Again, I said it will be relevant again, that is relevant.
Mr. Mpofu, what is the legislative basis for that?
Yes.
Was it based on the word decision, and any decision of a court may be taken on appeal as used in Section 21, subsection 1 of the Supreme Court Act? Because I don't have a difficulty with that.
Yes, ma'am.
Where the difficulty comes in is from August 2013, when that Section 21(1) and the reference to decision, which I take it as the statutory basis upon which the Basson case was decided. I haven't looked at it, but certainly it featured in the Western Areas judgment. And that was changed because of the provisions of the Superior Courts Act.
Yes.
And I think that's the thrust of the state's argument.
Objection. No, fair enough, my lord.
It's really, I don't quite know what weight one can still attach to the pre-2013 jurisprudence on this issue.
Yes, my lord. My lord, I can assure your lordship that that case, remember, that's exactly why I said, my lord, there's a route, the Zweni route, which deals with all those issues. Is it a decision? Is it final in effect, and so on and so on?
Mm-hmm.
That's the one leg of approaching the matter. And I'll address it just now. I'm now addressing the leg of, firstly, interest of justice, but also the interpretation, whether the word conviction should be interpreted narrowly to prohibit an appeal at this stage. Unfortunately, my lord, if your lordship also has an updated book of the toy, your lordship will see that this case is cited in the 2021 in the current, so it's clearly not affected by whatever legislative changes might have been to Section 21, but also, more importantly, this part that I just read out comes out of the commentary to Section 216. And the heading there is matters which are appealable. So it's exactly the point that has been raised. The short point, my lord, is this.
Sorry, could I interrupt you? Could I ask you, your junior, to make copies of those, because our
Yes.
loose leaf volumes have fallen
I know, my lord.
way behind,
I know.
and they're not going to be apparently replaced.
Updated soon. Thank you, my lord. No, yes,
So if it's 2021,
Yeah.
the law report stopped from 2019, so I don't think I would have those.
no, you want.
You can, even if it's dropped off just at the end of the day with my
We will, my
registrar.
lord. We'll actually, it's a 2-page section. The section on appealability.
As long as it
We'll
just, thank you.
As court pleases, my lord. Now, I was saying, my lord, that the Basson case, really the shorthand, if we want to cut to the chase, is that it did away with the Adams approach and dealt with the matter in relation to Section 1061F of the Criminal Procedure Act. And my lord, it's what we lawyers call a fortiori. If I can borrow. Can I borrow?
Yeah.
Thank you. So, my lord, I didn't bring the big one, but fortunately, Mr. Britton brought it. Your lordship knows the pleas A to AI under Section 101, rather 106. And one of them is that the court has no jurisdiction to try the offense. Incidentally, that's the one that has been singled out as is not capable to lead to an acquittal. So it's a lesser being, that section. It's literally like an exception even in civil proceedings. But the Constitutional Court has found that even for Section 161F, a matter is appealable because it would be in the interest of justice, again, to avoid a lengthy trial which has no legal basis. So how much more for Section 1061H, read with Section 1064, which are the sections that may lead to an acquittal. So a fortiori, as lawyers would say, if you can appeal against a 1061F finding, which is clearly intermediate, to avoid the confusion between interlocutory or otherwise, then it's clear that what the Constitutional Court was saying, based on the issues that I've raised, was that it would be absurd to the extreme to subject a person to a trial. And as the court said in the quotation I said earlier, it is surely not in the interest of justice to submit an accused person to all that. Surely. So surely the objection based on the narrow reading of 1064 negates logic and the interest of justice, if we understand what justice really means. The other point related to that is the fact that is a point that we have made, my lord, but I don't want to, again, to develop it. It's a construction point. So we say, if we all accept that one of the outcomes of the process that happened there could have been an acquittal, one of the logical outcomes, And then at that point, the matter would have been appealable, even by the state for that matter. Then, as a matter of logic, the non-acquittal or the failure to acquit, which is really what transpired, must also be susceptible to a challenge by the victim thereof. Surely, again, I'm sure that's what the Constitutional Court would say. But the bottom line is that it is surely not in the interest of justice to submit him to a lengthy trial, or to submit anybody, but for that matter, even the court, to a lengthy trial which may come to zero. Just rounding off, my lord, this, I can feel it in my body that there's a particular passage that I have not read out.
This is the last point that you're dealing with in your address, Mr. Mpofu. Yes, when you're done, then we'll take the short
We
adjournment.
take a break, that's right.
I assume, rightly or wrongly, that you might be winding down on your point.
Yeah, no, you assume rightly, my lord. That's why I'm just looking for, just to see that I don't have to rise up again. Yes, no, let me come back to that point which I made earlier, where the connection between what I've said is the fundamental bedrock of this judgment, and the because it also deals incidentally with the res judicata and issue estoppel point, so it will relieve Mr. Masuku of having to deal with that. My lord, the fundamental error, with the greatest respect, that your lordship made in relation particularly to the Zuma versus DA matter was this: the accused person, former President Zuma, an applicant in this matter, is left in a no man's land of the judiciary. The Supreme Court of Appeal, or rather even this court, when there was an application for a stay, says we cannot deal with this matter. It must be dealt with. All these complaints you are raising about Mr. Downer and all sorts of other people must be dealt with by the trial court. The trial court is you, my lord. We all know, at least your lordship says in the first part of your judgment, that the trial commenced in May 2021, correctly so. Because on the day that we submitted our section 106 and 1064 and 115 statements, the trial started in earnest. And the plea process is part of the trial. There's so much authority on that. I don't even need to convince your lordship about that. So if we all accept, therefore, that we are now in the trial, then it means we're at that place that these previous courts were saying the matter of Mr. Downer has been dealt with. But your lordship, with the greatest respect, makes two fundamental errors. One says that this matter must also be postponed to some other stage called the end of the trial. And I've already addressed why that is manifestly unjust.
I don't think I said just the end of the trial. More generally, the end of the trial, unless in the discretion of a presiding judge he decides during the trial. But anyhow, it's on the record.
I'll take your lordship to your judgment, but my team will look for the passage. There's more than 5 or 6 places where your lordship says that the matter should be entertained at the end of the trial. But let's assume I'm correct. The second problem with that, my lord, is that your lordship then also upheld the res judicata and issue estoppel objections with respect erroneously for 2 reasons. One, because those points had been abandoned, for lack of a better word, by the NPA. And that's why we didn't even address them seriously, because they had correctly considered, particularly in the question of issue estoppel, that it might not even apply in South African law. But let's assume we're wrong, because of course, as I would, they don't want to look a gift horse in the mouth. So they've now resuscitated those points which they had abandoned. That's fine. But on the merits of that, my lord, that upholding those points loses a very significant matter and is severely prejudicial to the interests of Mr. Zuma. Why? Because it cannot be that he is told by those courts that this matter must be dealt with here. And then when he comes here, he's told that those matters are res judicata. That means there's no court in this world where he must be able to raise this issue. He must be caught in this merry-go-round of judicial passing off the buck. So we can't, my lord, have a situation where Mr. Zuma is not able to assert this, rightly or wrongly, win or lose, we don't care. But there must be a forum in this country where he is able to assert his complaint. May pause, my lord. I know that there are many references, but for now I'll give you this one, my lord. The lordship said at paragraph 135, against the letter F, which is on printed page 57 of your judgment.
Yeah, the passage I think I mentioned earlier, I think was made in the context of referring to Delport's case. But we can read that, Mr. Mpofu.
Yes, yes, there is also that part here, where it's dealt with in relation to
because there the roast during.
Yes, the lordship said that imperative remains even on the evidence adduced in the affidavit to date. It is concluded that it has not been established that Mr. Zuma has or will suffer child-related prejudice and so on. This judgment cannot stand in the way of possible fresh evidence emerging later. Well, that's also important, by the way, in relation to the new evidence issue. The lordship again was correct, but this is the point. The inquiry is one most best answered by the trial court at the end of the trial, when the materiality of all the evidence adduced can be assessed properly. That's what your lordship said. Yeah. And that's what we say is fundamentally unjust and fundamentally incorrect. Yes. Paragraph 77 as well, my lord. Actually, these paragraphs, ironically, are quoted in the heads of our learned friends. The Lordship said, but that is something, Mr. Zuma's fair trial arises during the trial when they can be revisited to ensure at the end of the trial, Mr. Zuma will have received a constitutional fair trial. But there's something to consider during the trial only when the materiality of any such allegations in respect of issues and evidence revealed to be relevant are established. Any infringement of fair trial rights, which is the true basis of Mr. Zuma's complaint, is best determined when the evidence in the criminal trial has been heard, digested, and in the light of conflicting evidence, and the credibility to be attached to the evidence has been properly assessed. And this is what also was said in the spy tapes case, Your Lordship said. The possible infringement of fair trial rights does not arise for consideration under the special plea. That was the bottom line. That is what I call the heart of this judgment. The heart of this judgment. And that is fundamentally incorrect, my lord. Because why would anybody have to wait till the end of a trial if their Section 35 rights guaranteed by the Constitution are being threatened at any stage? Surely, the correct position in law is that that is exactly one of the considerations in the Basson line of cases. Yes, the point, I can, just to save time a lot, the Lordship will see that in the heads of the state, it's also, well, again, for understandable reasons, the heart of their defense, which is say, no, let's do this at the end. Forget about whatever prejudice may have been suffered now. We'll see it in 2025. Now, that gist and what I've called the heart of the judgment, my lord, is a manifestation of the greatest form of injustice. And in cases such as S versus Twala, which the other side have relied on, it has been made very clear, my lord, that one of the fundamental rights enshrined in our Bill of Rights is Section 35.3.0. We know that Section 39.2 says we must construe all these things against the Bill of Rights. Whenever you are interpreting any legislation, you must do it in conformity with the Bill of Rights for obvious reasons. So what does the Bill of Rights say? It says every accused person has the right to a fair trial, which includes the right, 35.3.0, of appeal to or review by a higher court. Now, that right, with the greatest respect, cannot be sacrificed at the altar of speeding, just speeding for the sake of speeding. That right, if it's going to cost us time, so be it. So be it. But that right cannot be abrogated. It's a fundamental right. The drafters of the Constitution knew what they were doing. They didn't say an accused person has a right to a fair trial, which includes the right to appeal at the end of some lengthy trial, which might be expensive and to their detriment. So even looking at it from that point of view, from a purely interpretational point, my lord, it cannot be that these matters must be relayed to the end of the trial. I'm saying now on the merits. But I'm also saying, in the context of what I'm saying, in relation to the conviction point, it also relates to the right of appeal per se. And secondly, my lord, the lordship quite correctly, I have to give credit where it's due, has articulated the interconnectedness between the 1061H plea and the Section 35 in general. In other words, that these are two sides of the same coin. Surely then, the enjoyment by Mr. Zuma of his Section 35 rights cannot be postponed to some future unknown date. They must be exercised now.
Are those your submissions on this point, Mr. Wolford?
I'm sorry, Miller?
Are those your submissions on this point?
On this
Yes.
point, Miller, I'm just
Mr.
checking.
Mpofu, I'm worried about the time allocation,
Yes,
without wanting to rush you, because this matter is set down for 1 day.
yes. Well, my lord,
You've had an hour and almost 45 minutes now, and Mr. Masuku must still speak.
Mr. I've
And I
taken
don't want
Mr.
to-
Masuku's some of his time, so I'm using it.
Yeah, and I want to allow the same amount of time, obviously, for the state.
No, fair enough. Okay, well, I don't know what your lordship wants to do. If your lordship is saying, let's say for argument's sake, if you are saying we have 2 hours, then we can make sure that in our internal allocation we do it that way, and so on. I'm quite happy to work with the court.
All right. Well, I think you
But
can
not at the expense
you
of-
can discuss that with Mr. Masuku and with Mr. Breitenbach, and then when we
Yes.
return,
Yeah. Well,
because I understood that this was now the part that you deal with.
Yes, yes.
So
my
you've
lord.
concluded that.
Yes.
So let's take the short adjournment, and then you can. You've dealt with a number of issues that I understood Mr. Masuku was going to deal with.
Yes.
So maybe it can be curtailed, and he can be
He'll be very short. my
kept
lord.
to another 20 minutes or so,
Yes.
and then Mr. Breitenbach can start, and we can.
Can use the time.
Because I'm
Yes,
sure
my
you
lord.
also want to leave. You want to go somewhere else.
Thank you, my lord. I have to be somewhere else myself
I'm aware of it.
tomorrow.
Yeah.
Thank you, my lord.
We're all waiting with bated breath.
Yes, thank you, my lord. Yes, my lord, I agree with your lordship. What I'm proposing then, my lord, is that in any event, when I finished, I was going to ask for a break so that we can cut down on
All
Mr. Masuku's address. So maybe let's take that break now. If
It's-
I address you at all, it will be a minute just to wrap up.
Yeah,
And
it'll
then
be, it's now 22.
Mhm.
So you've had an hour and 40 minutes. We'll take a 15-minute adjournment.
15.
We'll start at 5 to 12. And then hopefully Mr. Masuku can
So, yeah, Mr.
wind up
Masuku
on his
will-
section in
No, my lord,
15 or 20 minutes,
Yeah.
so that we can move on to Mr. Breitenbach.
My lord, I'll use my privilege as the leader of the team to suppress Mr. Masuku.
Very well.
Some of Mr. Masuku's
We'll resume at 5 to 12. Court will rise.
No, that's fine.
I'll do that. I just find my phone, guys. I don't really see my phone roaming around here.
Yes. Wait. Just finish that. You just want to fetch.
Just come out of it. Watches. When I just turn off, I'm just looking at the machine operator.
Thank you, my lord. I proceed, yes. My lord, Mr. Masudu has kindly also allowed me to speak to just make two quick points, which I won't develop. I'll refer your lordship to the case of National Director of Public Prosecutions versus King, 2010-2 SACR 146 SCA is one of the cases cited by my learned friends. And the lordship could go specifically paragraph 41 thereof, and the judgment of Nugent J.A. at paragraph 52.
At, sorry, 4?
52.
52.
41 and 52. Yeah.
Thank you.
And the one at 52 makes the point about appealability in matters such as this. And it says, if the order was erroneously granted, I have no doubt that this is the time for the error to be corrected, failing which it might just as well never be corrected at all. Then, my lord, the closer to home, the Constitutional Court in the case of Tint versus National Public Prosecutors and others, and Zuma versus National Director of Public Prosecution, 2009-1 SACR CC. The lordship will find the relevant portions at paragraph 62 to 65, where it talks about leave to appeal and the interests of justice.
Yes, okay, thank you.
And that there they just say generally disallowing such litigation would ensure that the trial court decides the pertinent issues which is based to do, and would ensure the trial starts sooner rather than later. So we accept that there's a need to over that. But says there can be no absolute rule in this regard. However, the court's doors should never be completely closed to litigants. If, for instance, a warrant is clearly unlawful, and that was on the facts of that case. So just pointing your lordship to those references. Then the second point, my lord, which I have to get off my chest, and is what I will call one of our grounds of appeal is that this court, with the greatest respect, completely misconstrued or rather misapplied maybe Nduli and Porrit. Nduli, on the basis that we argued then that it was a pre-constitutional dispensation. It was basically interpretation which had nothing to do with Section 39(2), and should therefore not be relied on, or relied on with much caution, because that interpretation was clearly narrow because of its time. And then Porrit, more importantly, my lord, this is really, it's almost painful to have to discuss this. Porrit does not say what the judgment says it says. I made this clear, at least I got points from Mr. Chenkov then for my Afrikaans, that all Porrit does say is that it is not necessary, and I said it's onnodig on nie noodsaklik nie, that the removal of a prosecutor be done under 1061H. When you say something is not necessary, it doesn't mean it's prohibited. So this distinction between the removal and the lack of title is really not helpful. The only thing that Porrit said was that it's not automatic that you'll get an acquittal. There should be a further inquiry, 1064. You remember it was the so-called continuum debate that I had posited, my lord. The lordship found that it was not necessary to debate it because of the finding. But that's really all that Porrit said. But Porrit did not say that you may not raise issues of bias in the context of 106H. In fact, it said the exact opposite at paragraph 17. But this does not mean that a prosecutor can never be disqualified on grounds of bias or apprehension of bias, where his or her bias affects the accused's right to a fair trial. A prosecutor may well be disqualified. And the court relied on Smythe. You'll remember one of the cases we had debated versus Ushe Okunze. So that's just another reason why this case, as your lordship indicated earlier, would be a prime candidate to go to the SCA, because they might then get an opportunity also to clarify what the SCA meant in Porrit, which, with the greatest respect, we submit is not what was found here. And in any event, even the SCA might not be the last word, because this is a complex area of law, which unfortunately has not yet, the 1061H part, has not yet been decided. Apropos the so-called wide or narrow interpretation, which of the two interpretations? Of course, we contend for the narrow, or rather for the wider interpretation. Your lordship adopted the narrow interpretation. We accept that, but all we have to say at this stage is that another court might well agree with us that with the application of Section 39(2), the wider interpretation is the correct one. As the court pleases, we're indebted to the court, my lord.
Thank you.
I'll
Is
hand
Mr.
over to
Masuku still going to address? Yes, okay. Masuku, have you reached some agreement with the other side, with the state, on time?
My lord, we did not speak, but
Well, how long is your address going to be? Let me just see on that.
if I'm not interrupted, my lord, it's 30. I'd say 30 minutes.
Well, it depends how cogent your arguments are. 30 minutes, okay. You happy to fit in with that, Mr. Breitenbach?
My lord, I'd in fact agreed with his leader that they would end at 12:15, but I will live with him.
Yes, all right. Thank you.
My lord, I intend to deal with the issues that my learned friend, Mr. Mpofu, has not dealt with. The first one being the meaning that the court attached to Section 108 of the CPA, and in that regard refused to conduct a trial of the plea that had been handed down. That had been raised by Mr. Zuma at the commencement of the trial. The second issue, my lord, would be that your lordship found that you couldn't deal with the arguments, or rather the removal of Mr. Downer, on the basis that there was no application to have him removed based on bias or the lack of independence, and that the procedure we had adopted somehow was not sufficient for the court to have dealt with that issue on the pleaded grounds. Then the third issue that I need to deal with very quickly would be the impact of the SCA judgment. But I mean, that has already been addressed in a way by Mr. Mpofu, and so I don't intend to address that. But the impact of that, just to start there maybe, is that if this matter were to go back to the SCA would probably be surprised, because it would say to us, the facts on which we regarded as speculative, the facts which were pleaded by the NPA, the allegations made by the NPA, criminal conduct by NPA officials, or prosecutorial misconduct by NPA officials, to the knowledge of Mr. Downer, have not been tried. They remain in the same state that they were here prior to that. They remain as they were when the matter was last heard by the SCA. And so the appropriate procedure, which we contend is a fair procedure to have adopted, would have been to subject the plea to a trial with reading of oral evidence and with the right to cross-examine. As it stands, all the allegations made in Mr. Hofmeier's affidavit have never been tested in cross-examination, never been subjected to trial. The NPA has not been held to account for what they say they did in the prosecution of Mr. Zuma. They tell Mr. Zuma in an affidavit, this is what happened in your case. People interfered with your case. To the knowledge of Mr. Downer, people did all these things that are set out in the affidavits. And obviously Mr. Downer did nothing. In fact, Mr. Downer says in his subsequent affidavits, in the permanent stay and this application, no, these factors, these allegations of criminal conduct by the NPA officials are insignificant in the fair trial rights of Mr. Zuma. But we would like to cross-examine those observations. Like Mr. Zuma would like to know a bit more than just the view that the theoretical view that these have no impact on Mr. Zuma, because they have real impact on him. Mr. Zuma would have liked to tell the court what impact these allegations by Mr. Hofmeier has had on his political career, on his social standing in society. There's incredible prejudice that President Zuma has suffered as a result of the allegations that are contained in Mr. Hofmeier's affidavit. And we submit that a Section 108 procedure, in terms of which this plea of Section 161H had to be tried, should have been followed for exactly that reason, that the trial court was not entitled to reach the conclusions that the SCA reached. For example, that the evidence or the facts or the allegations of Mr. Hofmeier were speculations. It was not entitled. You can't come to the conclusion that these are speculative allegations when a member of the NPA, a senior member of the NPA, says, no, we were wrong. And I will take your lordship to just one paragraph where Mr. Hofmeyer comes out very strongly and says, we thought that we could leave this to a permanent stay application. And when we looked at the allegations, we thought, no, we can't do this because we have a duty as an NPA when such egregious violations of prosecutorial conduct have occurred. We have a duty to protect the image of the NPA. It doesn't matter what the consequences are, whether people are arrested or people are fired from work, it doesn't matter, we're going to do it. But here we are. Mr. Downer doesn't believe that any of those allegations made in Hofmeyer's affidavit are allegations that impact on fair trial rights. Your lordship accepts that argument, goes ahead and accepts the argument that the facts on which the allegations made in the affidavit of Hofmeyer are in fact speculation, they're hearsay, all sorts of words that seem to suggest that they're insignificant in the scheme of things. Well, but the court was not entitled to do so without having conducted a proper trial of those facts. By doing exactly what the SCA did, the court essentially moved away from what the SCA had in fact directed that it be done, which was to ensure that these allegations, which were raised by Mr. Hofmeyer as a basis for termination of prosecution, be tried in a court of law. They are not going to go away because the NPA does not want to deal with them. Those allegations are egregious in how they characterize the conduct of the NPA itself. And my lord, in your judgment with respect, there's not a single reference that I could find where your lordship went and looked at went and quoted from the affidavit of Mr. Hofmeyer to show what kind of misconduct, what kind of criminal activities were involved in the prosecution of Mr. Zuma by the NPA. And that has to be important because it is trite. A complaint of this nature that that there's been criminal misconduct in the prosecution of an individual ought to concern the courts. It ought to horrify the courts that the prosecution is defined in the terms that Mr. Hofmeyer has defined the prosecution of Mr. Zuma. It should not just be wished away. Mr. Zuma should not have to suffer the indignity of a cooked up prosecution. And I say cooked up because this is what the NPA itself says. There was manipulation of the prosecution for political reasons. But it is in the detail of that the court simply ignored. And had the court decided that they would subject this to trial, the NPA at the very least would have had to account for what is contained in their own affidavit that is pertinent to whether or not fair trial rights have been affected in this particular case. There is a dispute within the NPA itself in the first place. There is a group in the NPA which is led by Mr. Hofmeyer and supported by the others who believe that their unfair trial rights have been affected. There is another group that is led by Mr. Downer who believe that unfair trial rights do not arise. Mr. Zuma can perfectly have a fair trial in circumstances where Mr. Hofmeyer himself says in paragraph, and perhaps I should read in paragraph 240 of his affidavit, in page 240 of the record, and paragraph 275. He says, I argued that the prosecution should be discontinued. This is a senior member of the NPA, very senior to Mr. Downer. Says, I argued that the prosecution should be discontinued. I had investigated Zuma's allegations. In my view, they proved that McCarthy and Nguga had actively abused the NPA to discredit Mr. Zuma. Their motive for doing so was political. They believed that it was acceptable to use the NPA to assist Mbeki in his factional battle against Mr. Zuma. I felt that it was important to expose what they had done. I felt it was important for the NPA to send a clear message that the political interference in the work of the NPA would not be tolerated and would be exposed. Now, these are the people with this constitutional responsibility to ensure or to safeguard the integrity of a prosecution. This is what it tells the court. It says it was a grave intrusion into the workings of the NPA with the effect that Mr. Zuma's fair trial rights were affected. Mr. Downer doesn't believe they are affected. But we can't resolve that issue on papers, simply because the Supreme Court of Appeal found that Mr. Downer was right, that the determination of prosecution was incorrectly done. The facts on which it was alleged that the prosecution of Mr. Zuma would result in unfairness by the NPA itself must be a matter for trial. 108 should have been utilized because that's the fairest way of getting to the bottom of the matter. If an accused person complains that an unlawful act has occurred or criminal act has occurred in their prosecution, it is the duty of the court to first decide that question. Decide firstly the question whether or not there has been criminal conduct in the prosecution of an accused person who has made complaints of that nature. And you do that by conducting a criminal trial. And that trial would involve members of the NPA who are cited, who are referred to in this affidavit of the NPA, the very institution that seeks to prosecute Mr. Zuma, says we did wrong, but Mr. Downer thinks differently. And it is Mr. Downer's view that finally passes, that finally wins. But it cannot win the day without first resolving the fundamental questions of whether or not the conduct alleged by Mr. Hofmeyr in his affidavit is correct. Because if these allegations are correct, my lord, essentially what happened here was that this is a manufactured criminal trial. It was manufactured for political reasons, and you have to find out in a trial conducted with oral evidence being led whether or not the rot, where the rot goes to. Where does the political interference go to? Does it go into finding allegations that are flimsy to put up simply to discredit politically? Where has the rot gone? I mean, in fact, you don't have to go far, my lord. The affidavit of Mr. Hofmeyr says it all. And you can read a paragraph 276, which also says, he told us that listening to the recordings had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges. In other words, to discontinue the prosecution. This is a senior member of the NPA saying, you know what, I looked at this thing. It's like yourself, my lord. If, for example, there were to be an interference with your work, you'd be very angry with that. And you'd say, no, but I can't tolerate anybody interfering in my work. You'd have to stop it. If it's criminal interference, you'd have to report it to the police and have the police investigate it. And whatever investigation is done, the person who interferes with your work must pay the price. And this is what we're asking. Before you subject Mr. Zuma to the trial that Mr. Downer wants, ask the question, does the NPA or has the NPA made allegations? And these are not people with no knowledge. These are people with resources and knowledge. These are experts in criminal law. These are the they run the very machinery of prosecution. They tell the court something was wrong in the way we conducted this issue. Or Mr. Downer says, no, it is not. It will not impact on the fair trial. And the court then endorses a position where these allegations of impropriety, including involving the NPA, will not be dealt with. At what point is the NPA held responsible for violating its own code of conduct, its own statutory responsibilities insofar as it must conduct a prosecution independently, fairly, within the law? And this goes to the heart of what we argue should have been the meaning of title. Because there is no title to prosecute under these circumstances. And this is where, my lord, I must take your lordship to the title itself. The title itself is actually in the documents. And again, the court did not refer at all to the title that is set out on page, it's page 1008 of the record. And you'll see, my lord, there that Mr. Downer put his authorization from the NPA, and it says that authority to institute and conduct criminal proceedings. I, Moipone Nuku, Director of the Public Prosecution for the area of jurisdiction of the High Court in South Africa, KwaZulu-Natal Division, duly designated by the National Prosecutor in terms of Section 25, hereby authorize William John Downer to exercise on behalf of the Republic the powers mentioned in Section 20, 1A, B, and C of Act 32 in all courts within the Republic, and the case is cited there. That's the first thing. If you flip the page, you'll see there that there's also Elaine Zungu's authority, which gives Mr. Downer the authority to prosecute. But there's an addendum to that authority, and Roman numeral 3 of that addendum says the authorization is of no force and effect until the holder takes the oath affirmation provided in Section 32(2) of Act 32 of 1998. Of course, we don't have Mr. Downer's oath of office in the documents, but we take it probably is there. We don't quibble with the fact that it's there. But if you go to the oath of office itself, and you'll see if you flip on the next page, which is 1612, and that's the oath of office which Mr. Downer would have taken, which is taken under Mr. Kelvin Llewellyn Singh. It says, and this would be the full names of Downer would be William John Downer, do hereby swear that I will, in my capacity as prosecutor, uphold and protect the Constitution and the fundamental rights entrenched therein, and enforce the law of the Republic without fear, favor, or prejudice, and as the circumstances of any particular case may require, in accordance with the Constitution. So the requirements of I'm almost done.
No, it's fine.
My Lord, I did say 30 minutes, and
Yes.
I am done. I can see you're looking at
No,
the
no.
watch, but I don't know whether that's an impatience to show me that I must do. But
No,
I'm making a very important point.
I was just checking. What is the page number that you're
No,
referring to now?
it's page 1612. I'm making an important point.
Yes.
And when I make an important point, and then you look at it tells me that am I done?
Mr. Masuku, I was purely looking at how the day is unfolding. I'm not putting pressure
Okay.
on you on that respect.
No,
Please,
my Lord,
I
when
think
you look
you're-
at the watch, it's putting pressure on me.
Yes, I did look at my watch to see what time it was left.
Yes, but I'm conscious of that, and my leader here is looking at the
Mr.
time. and
Masuku,
he'll make sure that I leave.
let's move on. We're wasting time
Yes,
now,
okay,
please.
okay. But anyway, the point I'm making, my Lord, is this: if you look at the authorization itself, it mentions the very principles on which we said he doesn't have title. The principles on which we said expand the meaning of title to include loss of title on the basis that he can never prosecute in terms of the law. He cannot prosecute, but it cannot uphold the law and protect the Constitution. He can't do it because my Lord, he has a duty when faced with these allegations to make sure that the NPA purges itself of these allegations before he can come to the court and say Mr. Zuma will have a fair trial. If he contests that there's going to be a fair trial, then what he must do is he must accept that the allegations made by his boss in the NPA, which are very serious allegations of NPA criminal conduct, must be subjected to a trial, in which evidence will be led, cross-examination will be done. Your Lordship dismissed some of these allegations, speculation as unfounded, and without any cross-examination being done, without anybody having asked Mr. Downer, why do you think this is Mr. Hofmeyer says that there were spooks involved, foreign spooks involved in the prosecution of Mr. Zuma or in the investigation including Mr. Zuma. Why do you think this does not have impact on his fair trial? We would like to know. It's simply not sufficient that is answered by an affidavit and it's decided by the court on paper. Finally, my Lord, on page 165,
Page 165.
sorry, so I'm trying to okay, no, I took the wrong. On page 286, paragraph 512. There were allegations that the NPA was trying to, in fact, when the DA reviewed this particular termination of prosecution decision, it alleged that the NPA was trying to hide some things. And the response of the NPA is that we're not trying to hide anything. As pointed out above, Mshe and his deputies were so alarmed by evidence of political interference in the affairs of the NPA that they recommended that a judicial inquiry be established to investigate the matters further. Of course, that was not done. And then on page 165 of the same affidavit, in paragraph it's page 165 of paragraph 23. We made the allegation that the NPA under Hofmeyr said that the gravity of political interference was such that it was clear that the prosecution was being directed from not within the NPA, but from outside. And paragraph 23 says, until he listened to the recordings myself, and this is Hofmeyr speaking, says until he listened to the recordings himself, Mshe had been unaware of how deep McCarthy's association with Ngcuka still was. Most senior members in the NPA, including Mshe, knew that McCarthy and Ngcuka were still friendly. We were aware of the extent to which Ngcuka, using McCarthy as his proxy, was involved in directing the Zuma prosecution and possibly other investigations and prosecution. It was Ngcuka working with others and not McCarthy who ultimately decided when Zuma should be charged. That's a member of the NPA. Why is the court not wanting that to be subjected to a trial? Why should the rot that is set out in Hofmeyr's affidavit, which clearly shows that there's been criminal conduct by members of the NPA to the knowledge of Mr. Downer, be simply swept under the carpet? Because we say that a fair trial would require that those allegations are investigated. And Your Lordship, after oral evidence has been laid and has been tested and everything has been tested, you can come to the conclusion that that's speculation. That's irrelevant. That is. But before that, with respect, my lord, that is not fair that Your Lordship decided to decide this matter on the basis of affidavits. And it's completely incorrect that Mr. Zuma never raised the issue of wanting oral evidence being laid. I do recall that I raised it both here in both in Your Lordship chambers and here in an open court, that this plea had to be, we would be asking at some point that it be tried orally or it be tried through leading of evidence. In fact, it was also raised in our reply, but it was raised in our reply because what then happened is that the NPA completely denied every allegation on which we sought to persuade Your Lordship to extend the meaning of title to mean that lawful title. In other words, the authority of the NPA to conduct a lawful prosecution. When you've been a witness of such grievous allegations of criminal conduct involving a prosecution, can't be suggested that you still carry you should still carry my learned friend, Mr. Trenkov, argued previously, that there should be a reward given to Mr. Downer because of his exceptional work. He is a witness to criminal activity within the NPA. But that has not been tried. And we ask Your Lordship that another court may direct in very specific terms that this court gives this plea the trial that it deserves, which will serve a number of reasons. It's in the interest of justice to do so. One of them is to ensure that the accountability of the NPA in ensuring that a clean prosecution has been done is achieved. The second one is to assure the public that the NPA's conduct is as serious to the courts as it is to everybody else. When allegations of criminal misconduct has been laid against the NPA members, to the knowledge of the prosecutor, those must be dealt with firmly before any criminal accused is put through a trial. those are my submissions, my lord. I apologize if I exceeded the time. I was
No, can
allocated.
we check?
My lord?
Can we check now?
No. You are. I think I exceeded maybe by 2
Mr.
minutes. Or so.
That's on a light note, and
Yeah, no.
you made it with a minute to spare, I think.
No, thank you, my lord.
Are those your submissions?
For your accommodation? I
Yes,
appreciate it.
thank you, Mr. Masuku. Mr. Braden, no?
Thank you, my lord. May I too remove my mask for?
Yes, as long as you're comfortable with it. I don't know that I can really grant the authority, but there it is.
I'll take my chances. It's hard to speak through the mask. Thank you. My lord, we shall address the 4 applications brought by the first accused in the order in which they are dealt with in his heads of argument, and shall attempt to confine our oral argument to the main points on behalf of the state. The first issue then is the alleged irregular procedure in the application for leave to appeal. As the court knows, Mr. Zuma contends that the court committed an irregularity when it directed that the state deliver an answering affidavit, and he deliver a replying affidavit in his application for leave to appeal. And his point was that no statute or rule of court makes provision for such affidavits. Now, we've heard this court's elucidation this morning of its directive regarding the filing of answering and replying affidavits. At the time, we misunderstood it. We thought it applied to both the application under Section 3161 for leave to appeal and the application under Section 365.
Sorry, just give me a moment. Sorry. Yes, Mr. Breitenbach, I've just been told that you're speaking quite softly, so you must move right in front of a microphone, not a press microphone, but a court microphone. Perhaps is that thing's on wheels? Well, then just move it up, please.
Thank you.
Sorry to have interrupted you, but please continue.
I'll start again for the...
No, you said it was misunderstood, and obviously in the fullness of the judgment, I will set out the verbatim wording of the letters,
Yes.
and it can then be decided whether it was a justifiable error or not. But yes, the state also proceeded on that basis.
No, we accept that we have misunderstood it.
Yeah.
As applying to both applications, the
Yes.
316 application for leave to appeal and the 3165 application for leave to adduce further evidence, and not just the latter. But we submit that this court's elucidation, which my learned friend Mr. Mpofu accepted this morning, removes Mr. Zuma's cause for complaint, because it's a complaint against the court, and the court has now explained what was meant. From a practical point of view, what it means for Mr. Dana's affidavit, this is now his answering affidavit that was filed in December, is that it is admissible only insofar as it deals with the 3165 application for leave to adduce further evidence. In other words, paragraphs 48 to 63, which are at pages 64 to 69 of the record for purposes of today's proceedings. Lastly, in this connection and in any event, we submit that the state's delivery of an answering affidavit in the 3161 application for leave to appeal did not prejudice Mr. Zuma. On the contrary, it facilitated the early identification and delineation of the issues in dispute. In the period since mid-December, when the state's answer was delivered, Mr. Zuma and his legal team have had ample time and a proper opportunity to respond to the state's points. Lastly, those points have now been repeated in the state's heads of argument, against which no objection is taken by the other side.
Yeah.
That then brings me to Mr. Dana's alleged conflict of interest. Mr. Zuma alleges that Mr. Downer should not have deposed to the state's answering affidavit in the application for leave to appeal or the application to adduce further evidence because the special plea in terms of 1061H concerned him, but related, in other words, to him. Now, we deal with this issue in our heads at pages 6 to 7, paragraphs 13 to 16, and we make 3 submissions. In brief, they are the following. Firstly, Mr. Downer is best placed to answer the allegations concerning him in these proceedings. We make this point in our heads at page 16, paragraph 15, where we submit as follows. Mr. Downer made the state's answering affidavit in response to the special plea, without demur from the first accused. Doubtless, the absence of any objection to his doing so was because, as the person best placed to answer the welter of allegations against him, it was obviously right that he deposed to that affidavit. There is no good reason why a different deponent should make the state's answering affidavit in the application for leave to appeal against the dismissal of his special plea. Our second submission is that, far from having a conflict of interest, he has an identity of interest with the state. In other words, the state opposes the relief sought by Mr. Zuma on the same grounds, which are set out in Mr. Downer's affidavit, but which, as we've said, is not, that part of his affidavit is not admissible anyway. What is admissible is his opposition, grounds for opposition to the 3165 application. And the fact that there is an identity of interest between Mr. Downer, what he said, and what the state says, appears from our heads of argument. We have submitted those heads of argument on the behalf of the state, and there's no point taken that they were not, and that this oral argument today is not being adduced to you on behalf of the state. The last point is that Mr. Downer has been designated by the DPP to conduct the prosecution of both accused and to carry out any functions incidental to the prosecution. My learned friend, Mr. Masuku, read from that designation today. We submit that deposing to the state's answering affidavit in these proceedings is a function incidental to the prosecution. The state is entitled to select the deponent to its answering affidavit. That then brings me to the first big point for decision in this matter. And it relates to our contention that Mr. Zuma has no right to seek leave to appeal to the SCA. We understand them to have abandoned the application insofar as it relates to the full bench under section 316(1)(a) of the Criminal Procedure Act, unless and until he has been convicted and sentenced by this court. Now, our argument here has 4 building blocks, and they are the following. The first relates to the wording of section 316(1)(a), which deals with appeals from the High Court to the SCA. It provides in paragraph A that, and we quote, any accused convicted of an offence by a High Court may apply to that court for leave to appeal against such conviction or against any resultant sentence or order. Our second point is that although Mr. Zuma's special plea in terms of section 1061H of that statute has been dismissed by this court, he has not been convicted of any offence by this court. On the contrary, in its judgment, the court concluded by directing that the trial of the accused on their pleas of not guilty to the criminal charges preferred against them by the state must now proceed. At the conclusion of that trial, Mr. Zuma will either be acquitted or convicted. The third point concerns the interrelationship between Chapter 31 of the Criminal Procedure Act, that's sections 315 to 324, and Chapter 5 of the new-ish Superior Courts Act, that is sections 15 to 20. Our contention is that sections 3161 and other related provisions, notably 315, in Chapter 31 of the Criminal Procedure Act, deal expressly both with the circumstances and with the manner in which an accused in a criminal trial in the High Court may appeal to the SCA. As a result, we submit those provisions are not supplemented by Chapter 5 of the Superior Courts Act, the chapter dealing with appeals generally. It regulates, as the court knows, amongst other things, appeals from the High Court. On the contrary, we submit appeals by accused persons in criminal trials in the High Court to the SCA are expressly excluded from the ambit of Chapter 5 of the Superior Courts Act. And that is due to the definition of the word appeal in Section 1 of the Superior Courts Act, which provides that in Chapter 5, unless the context otherwise indicates, the word appeal, and I quote, does not include an appeal in a matter regulated in terms of the Criminal Procedure Act. And we submit the correctness of these propositions can be tested by comparing the facts of the present case with the facts of the leading constitutional authority, Leashing, SV Leashing, Liesching, and others, 2017, to SACR 193 Constitutional Court. It's number 5 in our bundle at pages 18 to 27. In the present matter, we contend Section 316(1).
It's a different factual scenario.
Completely different.
Leashing deals with an appeal in respect of the refusal by the President of the Supreme Court of Appeal to refer a refusal of a petition for consideration by the court, the SCA. Now, it flows from, I think it was Jacob J. and Chwala. Or it might have been, no, I think it was Musi AJ in the previous Leashing matter. Yeah, that's correct. Saying that the provisions of of the Superior Courts Act and also the Criminal Procedure Act, they are comprehensive but not exhaustive.
Yes.
It was Musi AJ.
Yes.
And it's for that reason that because 316 doesn't deal with an appeal post what would normally be the final step in the criminal judicial process. That is where where two judges of the Supreme Court of Appeal have refused a petition, and the President then refuses to have that reconsidered. That is something not catered for in Section 316 or 317 or whatever that chapter is, Chapter 31 of the CPA, and one can understand that. We're not dealing with that situation. We're dealing with a situation pre-conviction. You understand your argument that it's 316, and I think 315 also deals with it, that it requires, there's no appeal until conviction, and then in respect of conviction, sentence, and any incidental orders or something like that the section speaks of. Does that exclude, though, taking into account that the provision is comprehensive but not exhaustive, the situation like, for example, a special plea on jurisdiction that, let's, for argument's sake, accept, was rejected for totally the wrong reasons, which brings us back more to whether it would be in the interest of justice that an appeal be pursued at that point, which almost smacks of Western areas and what Howie P. said there. But the problem with that is that, well, not the problem. Although the court there didn't act on it, Howie P., the president, said that the legislative authority for that is section 21(1). Now, it seems to me that in Lishing, the basis upon which the court proceeded was that the word, quote, decision, unquote, in section 17 of the Superior Courts Act would include the kind of decision that the president of the Supreme Court of Appeal had taken. Now, couldn't that interpretation be extended to also include, for example, a special plea on jurisdiction, notwithstanding that prima facie still forms part of the trial, i.e. pre-conviction, and therefore not expressly within the provisions of section 3161A. That's really the crux of the issue, isn't it?
On this particular issue,
Yes.
I do agree that you've put your finger on it with respect, my lord. May I suggest that we approach the matter this way?
Yeah.
There are three important cases. The first one is Western Areas, which was decided in, let me get the date precisely correct, on the 31st of
2007,
March,
somewhere around there.
31st of March 2005.
5.
The second is the case referred to by my learned friend, Mr. Mpofu, this morning, the 2007 Basson judgment.
Case.
And that case concerns section 319, not 316. And the third is the Constitutional Court's judgment in Lishing, which is in 2017. Now, as your lordship pointed out, at the time when Western Areas was decided, we were in the regime of the old Supreme Court Act of 1959, and section 21 sub 1 of that act conferred on the appellate division, then appellate division, SCA, authority to hear appeals generally in addition to any authority conferred on it by other statutes. No such provision is to be found in the Superior Courts Act, and in fact the Superior Courts Act goes the other way by generally excluding from the ambit of Chapter 5 the appeals provision, appeals which are dealt with or regulated by the Criminal Procedure Act or any other criminal procedural law. So what does one make of that? Well, we submit, my lord, that the provision in the Criminal Procedure Act, which caters for questions of law which arise at any stage in criminal proceedings, is section 319. Sorry, 319. Yes. So if a dismissal of a special plea, or indeed the upholding of a special plea concerning a court's jurisdiction, turns on a question of law, that question can be reserved for the consideration of the SCA under section 319. Equally, if the upholding or dismissal of a special plea under section 1061H concerning title to prosecute turns on a question of law, that question may, in the discretion of the trial court, be reserved for the consideration of the appellate division. There is no need to try and shoehorn an intermediate appeal, such as the one which has been sought in this matter, into section 316, if the question is one of law. And if I may go to the end of my submissions, I said I would deal with them in the order in which we deal with them in our heads of argument.
Yeah.
But as the court knows, we contend that, and have always contended, that Mr. Zuma's special plea under section 1061H is acceptable on its face because the grounds raised in support of it do not relate to the word title, properly construed in section 1061H. Mr. Zuma's response to that, his counsel's response to that, is to contend that title should not be interpreted in the manner for which the state has contended. In essence, they contend in the main that Porritt's case was wrongly decided and that it bears a wider meaning. That's a question of law. We accept that. If one looks at our heads of argument, we don't contend that an application under 319 would be incompetent at this stage. In other words, there is no jurisdiction. Such an intermediate appeal is not viable. We accept that insofar as what is raised is a question of law, this court does have a discretion to refer it. But we will, and I'll deal with this in more detail when I get there, we say three things about that application. The first is, it is clear from the authorities that such a referral will not be made where there are no reasonable prospects of success. And as I shall elaborate in a moment, there are no reasonable prospects of successfully persuading the SCA that Porritt was wrongly decided. The second is, it's a discretionary power which is conferred on this court. And obviously, one of the factors that will be considered in the exercise of that discretion is the interests of justice. And I shall deal with the various reasons why we submit that an appeal at this juncture would not be in the interests of justice, and indeed would be contrary to the interests of justice. And the third is that Section 319 is there to allow a High Court to refer to the SCA for its consideration and decision, a question of law which it has not already decided. It doesn't say so in terms, but that must be the purpose of the provision. In this instance, we are dealing with a question of law which the SCA has decided. In Porritt's case, the proper meaning of title. And so,
Well, they say it should be reconsidered.
I
But
understand.
should I, is it this court's function to assess that? Or is it this court's function to look at it and say, according to our principles of austerity decisis, court is bound, even if I might disagree with it.
Yes.
And if it's to be pursued further, then ask the SCA by way of a petition, whether it wants to deviate from its previous decision.
And that, my lord, is the last thing I wanted to say.
Oh.
That brings us back to the relationship between 319 and 316. The fact that the court refuses to refer a question to the SCA for consideration at this stage doesn't preclude the defense, if the accused is ultimately convicted, from raising the point as a ground of appeal. It will obviously have to seek leave to do so, just as in essence it seeks the court's leave for the referral of the question at this juncture. So that, my lord, is how we see these three strands of the law fitting together. It is a little complex because of the change in the general statute regulating high courts, the Supreme Court Act being repealed and the Superior Courts Act being put in its place.
Yes, my earlier comment really referred to that whether Porritt is to be followed in the future, the appropriate entity to ask is the Supreme Court of Appeal by way of petition.
Yes. And it,
Because as things stand at the moment here, if I consider it on all fours, I'm bound to follow it. I don't have an option,
yes,
as the full court would have.
hence the abandonment of the appeal.
And in
to
fact, the
full court.
SCA doesn't have a full, a carte blanche authority. It must be satisfied that its previous decision is wrong.
Clearly
But that's a call that it would have to make.
yes, clearly wrong, my lord. It's a
Clearly
higher
wrong.
standard.
Well, that's a Camps Bay case, isn't it?
Yes.
Yes.
Otherwise, the doctrine of precedent will be upended, and that there are various legal interests which would be adversely affected by that. Open-ended consideration and reconsideration of questions. So, my Lord, may I just then briefly finish the argument on 3161A? So what we essentially agree with your Lordship. The essence of the distinction, I'm just looking at leashing on the facts. May I commend to your Lordship on the law, the most important paragraphs in the leashing judgment are all on page 23 of our bundle. They are paragraphs 23. They're paragraphs 36 to 44. And later in the judgment, His Lordship applies the law as stated there to the facts. Let's just start with leashing's case. Leasing, unusual factual situation. Three people were convicted of murder. It seems the evidence of one witness played a big role in that. They were sentenced to lengthy periods of imprisonment, and then a fourth person was tried separately from.
I've read the judgments, both of them.
And he recanted the evidence that he'd given previously.
Mm-hmm.
Unfortunately for them, by that time, they had applied unsuccessfully for leave to appeal in the High Court, and their petition to the SCA had failed. They asked the President of the SCA, under the proviso to Section 17(2)(f) of the Superior Courts Act, to refer their petition back to the judges who received it for reconsideration, because it was essentially now a petition for something different, for an appeal in which they would seek the leave of the SCA under Sections 316, 12, and 13 of the CPA to lead this further evidence. And the President said no, they'd reached the end of the road as far as that proceeding was concerned. They had to use Section 327 of the Criminal Procedure Act, which caters for this situation but allows the Minister of Justice to refer the matter to the court, which will then hear the evidence, and if the court believes that the result would have been different, to then make a recommendation to the President for the exercise of his or her prerogative as to pardon, etc. The CC approached the matter on this basis. It said the Criminal Procedure Act procedure had run out. There was no further appeal. The Section 327 process is not an appeal. It is a process which may or may not result in a pardon being granted by the President, by the executive, by the person in his capacity as head of state, actually not the head of executive. And it's in those circumstances that Chapter 5 supplements the procedure in the Criminal Procedure Act. And as I've endeavored to explain, our Criminal Procedure Act has provisions which deal with, firstly, when an accused may ordinarily appeal, and secondly, with the reservation of questions of law at any stage in the proceedings, not just at the end of the proceedings, so says Lasson's case in 150, para 152. And so we do have a procedure under which hasn't run out. So the real application before you today we submit is a Section 319 application, not a 316 1A application. You may ultimately, if Mr. Zuma is convicted on any of the charges against him, be faced with a 316 application in which the leave to appeal is sought against the dismissal of his special plea. That's assuming your Lordship doesn't exercise the 319(1) power in their favour in the meantime. There was some reliance placed on Section 3530 of the Constitution as an alternative basis. My learned friend argued it orally this morning. That provision, as the court knows, provides that every accused person's right to a fair trial includes the right of appeal to or review by a higher court. That's the wording used. But as your Lordship mentioned, in Twala's case, 2000 Volume 1, SA 879CC at paragraphs 9 to 11, the court interpreted that provision in a way which makes it clear that it applies only to appeals against a conviction or sentence. So we submit that Section 3530 of the Constitution doesn't provide.
What are the paragraph numbers again? Sorry, I didn't make it.
So it's paragraphs 9 to 11 of Twala. They're in our bundle.
Yes, no, I've read
pages 41 to 42. Now, assuming, my Lord, that you're against us on our primary submission, And what I'm now going to say also relates to the exercise of your Lordship's discretion under Section 319 in relation to the request for the reservation of a question of law. In both instances, the following question arises. Would an appeal at this juncture be in the interests of justice? And we accept that your Lordship will have to get to that question insofar as what is being sought from you is a request for a referral to the SCA for a reconsideration of its decision in Porritt, specifically Porritt Para 7 and Para 8, as to the meaning of title in 1061H. Here, the Western Areas case is, we submit the leading authority, and specifically paragraphs 34 and 35. That's authority for the proposition that a decision which doesn't have the effect of disposing of a substantial portion of the release claimed in a criminal case should be taken on appeal intermediately, only if the interests of justice in doing so, in the particular case, outweigh the considerations which underlie the general rule against piecemeal.
Was that now?
appeals.
I was not clear on what was being conveyed there. Does that now deal with an appeal that doesn't meet the test in Zweni?
Yes. If one looks at those
If it's,
yes.
yeah, if it doesn't meet the test in Zweni, then it's really interlocutory in nature, and normally wouldn't have been appealable.
Yes. I
But-
hesitate to say this is interlocutory,
Well, sorry, it's
but it's not the
it's midstream.
yes.
Perhaps I should rather use that word than
Yes.
a phrase that is more appropriate in the civil context.
Yes. So that is what Justice Howie was saying. He said that Zweni is not the law of the Medes and Persians. Even if one doesn't meet those requirements, there may be circumstances in which the interests of justice, it's in the interests of justice to allow the losing party on this intermediate question to go on appeal. And my learned friend, Mr. Mpofu, has relied heavily on the part of that judgment which says where the result would be to put someone to the trouble, expense, stress, etc., restrictions on their liberty of a criminal trial, when ultimately it may turn out that there was no good reason for doing so.
Now, if such a question arises, and it's not a question of law, but one of fact, does that mean there can't be an appeal, even if it would save an accused suffering the expense and the stress and the hardship and everything of going through a lengthy trial?
May I answer the question this way? The only way in which, there are two ways in which that can be addressed. If it's an appeal to the SCA, this court would have to interpret and apply Leashing's case as meaning in the paragraph to which I referred you on page 23, the first of the one which talks about supplementation. Supplementation, in other words, by Chapter 5 of the Superior Courts Act of what's in the Criminal Code. Interpret that widely to cover any situation which is different from the way things are done or regulated by the Criminal Procedure Act, rather than, as happened on the facts of that case, to fill a gap. In other words, the road had been reached, the end of the road had been reached for Mr. Leashing as far as appeals were concerned, and the court said that's under the CPA. Yes, but there is this power inherent in the president of the SCA to refer the petition back for reconsideration. So that's where the
Was
supplementation
to fill a
comes
gap,
in.
you say?
So
Now,
your lordship would have to interpret the SC, the Superior Courts Act as supplementing the Chapter 31 of the CPA by allowing appeals in media res, in the middle of the case. We've argued against that. We say that the CPA deals sufficiently with it by allowing questions of law to go forward in the meantime, but not questions of fact. Those must wait until the end of the trial. But the argument I'm now advancing in relation to leave to appeal, as opposed to the application for the reservation of a question of law, is in the alternative to the submissions that I've just made.
Now, I've understood your question of 319 obviously would apply only if there's a question of law involved.
Yes.
But you're saying, well, if leashing is interpreted that way to fill a gap or to supplement the Chapter 31 situation, and what would govern?
Then
what would govern that interpretation? Would it be? Are we back to Western areas, whether the interests of justice require it? Is it discretionary? So it's not precluded, but whether it should be granted depends on my discretion in deciding, yes, it's appropriate because it is such a fundamental issue that could save a long trial, etc.
Applying the approach in Western areas, and this is, if I was in your lordship's shoes and inclined to go that way, this is how I would approach it. I would say that the principle that I abstract from leashing and from Western areas is that Chapter 5 of the Superior Courts Act supplements the appeal provisions in Chapter 31 of the CPA to allow an intermediate appeal, even on questions of fact or mixed law and fact, or it could have all three variants, where it is in the interests of justice that be done. That was essentially the bottom line of Justice Howie's judgment in interpreting and applying the very wide provisions of Section 21(1) of the old Supreme Court Act. He says what those wide provisions mean is if you can have intermediate appeals where the interests of justice, where it's in the interests of justice that happen.
Because as much as it might be appealing on a sort of a clean break, the notion that there's no appeal at all ever prior to conviction is quite a jump to make in logic.
Well, it's
yes. It was there on Section 21(1). It was there on Western areas. Cases have always said appeal shouldn't, or criminal trials shouldn't be disposed of in a piecemeal manner. 2008, round about there, the very strong comments by Langa CJ in Tint were expressed. Then at that stage already, the Superior Courts Act, I think, was in the process of being considered. The bill was. And I've tried to look at the history of it. It seems the definition of appeal only was introduced at the Justice Portfolio Committee stage. So it came quite late.
I was not aware.
Yeah, well, if my research is correct, as I say, I've had limited time. I've just been scratching around. The question then is whether by that introduction of that definition of appeal, which didn't exist in the in the Supreme Court Act, quite a drastic new dispensation was being contemplated for appeals in criminal matters. But it's not surprising that a new dispensation, if you like, in criminal appeals was being contemplated and was sought to be introduced because it fits in, if I can use some old terminology, with the mischief that Langa CJ was talking about in Tint, in the interim. And that's not even going back to Rosalie and what Mairead J said and in those cases, because the principle has always been piecemeal appeals or piecemeal disposal of criminal matters should be avoided.
Yes. So that principle remains. And my lord, you asked me what would the legal basis be for the general possibility of a general appeal, not just appeal on a question of law prior to conviction.
Yes.
I submit it would be
Is it a lishing, section
It would be-
17(2)(f)?
it would no.
What?
It would be rooted in the principle in leashing, which is specifically in paragraph 36, which I think I must take your lordship to, that the function of the Superior Courts Act is to complement and supplement the CPA. Our argument is, as the court knows, is that is where there is a gap, and that we don't have a gap here, and we certainly don't have section 21(1) of the old Supreme Court Act. But the argument against this, and hasn't been fully articulated, but this is a question of law, and in fairness, I must articulate as best I understand it the argument against the position which we've adopted, and it's rooted in paragraph 36.
Sorry.
At page 23 of our bundle,
Yes.
where Musi AJ, speaking for the unanimous Constitution Court, says the reason for the exclusion of appeals regulated in terms of the CPA or any other criminal procedure from the purview of Chapter 5, that's a reference to the definition of appeal, is to avoid duplication. It would be senseless to have two statutes regulate the same subject matter. The legislature recognized that although the CPA deals comprehensively with appeals in criminal matters, it doesn't do so exhaustively. Chapter 5 of the SC Act, insofar as it deals with appeals, complements and supplements the CPA. The purpose of the definition, therefore, is not only to harmonize the provisions of the two, but also to supplement the provisions of the CPA. Then he goes on to quote the definition of appeal, and he says in 38, the CPA regulates appeals in criminal proceedings in respect of superior courts in 316 to 324 and so on and so forth. Hence our argument that it is in fact regulated, but there is another way of approaching this. Your lordship may interpret complements and supplements as, because it's that is the interpretation of the Constitutional Court of this new dispensation, as meaning allows for these generalized intermediate appeals where it is in the interests of justice to do so. And that would be the argument against us, but rooted in the interaction between these two statutes.
But then you carry on and you say it's not in the interest of justice, even if there's such a discretion.
And assuming I've lost that argument, I'd like now to
Yes.
deal with the interests of justice.
Is it convenient, perhaps? I've avoided watching my watch, but I see we've exceeded 1 o'clock. And we need a comfort break for the benefit of those present. Can we resume at 2 o'clock? Or, well, let me give you a bit more. At 15:15.
At any time that suits you, my lord.
Yes.
I'm a
I
bit
just want
concerned
to,
about
I want to fit in the, you've had discussions with Mr. Mpofu.
Yes.
How long do you think you will still be? And then allowing some time for a short reply before we're running out of the court day. So before 4.
I will definitely make sure that I'm finished in time to give my learned friend time to reply. He has a very important engagement tomorrow,
Yes.
and it would not be desirable that we have to come back on another day to finish this.
Is that an order, Mr. Mpofu? We'll take the adjournment now.
Yes, my lord. Apropos your question, then maybe we should come back at 2, my lord. On that
At
basis.
2.
Yes, my lord.
And you'll be able to finish before 4.
We will. My lord.
Yes. All right. On that basis, then I'll come back at 2.
Thank you.
So the court will adjourn for the long adjournment until 2 o'clock.
As a pleasure.
Court will rise.